So friends, we are going to discuss Part C in Jurisprudence 2017 paper. Question number 15 is like this. A multinational industry was established in a peaceful area. But in view of the local authority like municipality or corporation, the industry is not meeting the objectives. Then you can think that it is causing environmental trouble to the local people. Then they come and approach you. Then what are you going to do? Whether you are going to file any case on them or not. This is what is required in this problem. First of all, what is a multinational industry, or you have to know what is a multinational company also. MNC, please remember, MNC is an organization or is an industry which is controlled from some other country, or which is owned by a foreigner, not Indian, and normally they produce or their control is on production of goods or services in one or more other countries also, not only in India. Suppose Microsoft, your headquarters is located in USA, their operation is in India, so many other Singapore, so many other countries also. So when they have got the production of goods or services in more than one country, then other than their home country, it is called a multinational company. So definitely the fact is that most of the companies, they are wealthier than a country also. ఈ కంపెనీ మైక్రోసాఫ్ట్ కంపెనీ వాళ్ళ బడ్జెట్ మన ఏపీ ఇండియా బడ్జెట్ అంటూ ఉండొచ్చును, మోర్ దాన్ దట్ ఆల్సో. సో దే ఆర్ సో రిచ్, రైట్. తర్వాత నార్మల్లీ we have to agree that the multinational companies or the multinational industries, they often employ definitely environmental technology, ETP, effluent treatment plant, like that. Definitely they oblige. But there are occasions where in their management practices they deviate from this. Therefore, the environmental pollution is caused. Why we prefer the multinational companies? Because they are superior in character, superior with the infrastructure, superior with the to the manufacturer with the compared to local companies. But please remember, they are causing large scale environmental damage, right? So example, best example is Bhopal gas leakage, is it not? In the year 1984, suppose if since it is Union Carbide Corporation, MNC by USA people, our Indian authorities, they do not have guts to touch the same. But if they checked properly, definitely the methyl isocyanate gas would not have leaked from the Bhopal gas, and which caused a tragedy. So MNCs, no doubt, you have to encourage, but at the same time, the troubles should also be looked into, right? So we go to the examples. In 2009, the AP Pollution Control Board, they asked SMS Pharmaceuticals Limited to shut down their Partc plant. You may be knowing, Hyderabad is famous for number 1, pharmaceuticals, number 2, glass. So this SMS Pharmaceuticals company, it is totally causing environmental pollution. Even though it is a multinational company, the government of AP, the Pollution Control Board, which is the competent authority, they have given directions. They asked this SMS Pharmaceuticals Limited to shut down the plant which is located in Partc. Why? Because local people, they protested. Local people, they raised objection regarding the environmental pollution. Then why? The reason is they treated the wastewater. They treated the wastewater, but still this water contained 21 different pharmaceutical ingredients, which are definitely hazardous, health hazardous to the purpose. Therefore, definitely they have to be vacated when they cause environment trouble. According to Environment Protection Act, whether it is a multinational company or not, definitely orders can be given to vacate them. Even in 2012, Aurobindo Pharma, it was asked to shut down its plant. So now we'll look at the case laws. Number 1 case law, GABA, G-A-B-A, GABA Pharmaceuticals versus State of AP 2006. Actually, this case started in 2012, 2002, but of course the decision was given in 2006. This is relating to Trimurti Pharmaceuticals. Trimurti Pharmaceuticals company. Of course, they are working under GABA Pharmaceuticals of other country, MNC. So actually, it is having the spirit more than required quantity, and it is causing so much of pollution. Therefore, it was asked to shut down. Second case, Saturn Pharmaceuticals. Saturn Pharmaceuticals versus State of Kerala. Here also, they are actually they are preparing the so-called medicinal preparations, for which alcohol is a necessary item. So they want to get the free alcohol. Of course, the government is actually they are considered enough to supply, but they have diverted the alcohol, and it causes pollution. Therefore, it was asked to shut down also. And third case is Plachimala, P-L-A-C-H-I-M-E-L, Plachimala versus Coca-Cola, 2016. This is regarding water war. So Coca-Cola, for the manufacturing, definitely they need 100% uncontaminated water. This Plachimala people, they used to take water from their area, for which these people raised objection. That too, they stated that you are creating water shortage plus environmental pollution. So when they are able to prove, Coca-Cola was asked to shift the supply motors from Plachimala to some other place. So friends, remember, to conclude, I want to tell you, whether it is a multinational company or not, everybody has to follow the environmental rules and regulations. And if they fail to obey the rules, definitely they can be asked to evict from the premises. Right? Next, question number 16. We'll switch on to the next question. This says, so please remember, a criminal who is disabled, kunti guddala untaru kada, criminal andaru bagundaలని ledhu kada, a disabled criminal was given a rigorous imprisonment. I think, I don't know, remember, just one brief facts raskunnanu, meer jagrata question lo chuskondi. So he was given imprisonment. Section is a rigorous imprisonment. Ralu Gordon Polidata. Simple imprisonment, Urne Kuchini, Atagari, jail authority, Alulaga Kuchin Tenta. So this rigorous imprisonment was given to the disabled criminal. But please remember, no proper treatment was given by the jail authorities. Normally, itano disabled, Kuntiwadu bathroom Galalante, somebody should be there to assist him. Professor Sai Baba case వస్తాను ఇలాంటి వాళ్ళ కోసం definitely the jail authorities should take some special measures. So ఈయన ఏం చేశాడు, he filed an appeal to the governor for tender of pardon. అయ్యా వీళ్ళని చూడలేదు, కనీసం మీరైనా దయదలిచి ఆర్టికల్ 71 ప్రెసిడెంట్కి అలాగే గవర్నర్ కూడా పెట్టుకోవచ్చు కదా. సో దాని ప్రకారం గివ్ మీ టెండర్ ఆఫ్ పార్డన్ so that I can go out and attend to the daily course. ఎందుకంటే డిజేబుల్డ్ క్రిమినల్స్ చాలా కష్టమైన పరిస్థితి. రైట్. సో ఈ మొదట్లో విల్ డిస్కస్ ది కేస్ ఆఫ్ మిస్టర్ ప్రొఫెసర్ నాగసాయి బాబా who was lodged in jail for so many years. So Professor Sai Baba, he was given life sentence by the Gadchiroli court of Maharashtra state. ఎందుకు? For his links with Maoists. Right? Okay. Actually, due to his advocacy, he is a professor in JNU, Delhi University. He professor actually he has encouraged certain students. 120B case code undi. So he is and others. So all of them were found guilty of the so-called links with Maoists and waging war against the democratically elected government and also for supporting the Maoists. Right? But you know the condition of Mr. Sai Baba. He is a wheelchair-bound teacher with 90% of disability. He was arrested in 2014 and kept in Nagpur jail for so many years. So actually, he is a totally afflicted or he is a wheelchair-bound person. Even To go for urine, some association necessary. To go for bathroom, some association, but nobody is assisting him. It has become very problematic for him even to use urination, and he has got a burning sensation at the time of urination. So you can see the case as G.N. Sai Baba versus State of Maharashtra 2019. So please remember. Of course, he was found guilty of so many sections. Unlawful Activities Prevention Act, Section 13, 18 and 20. Bombay High Court convicted him, and he was convicted under 120B of the Indian Penal Code also. Right. So, he is a disabled criminal. But the jail authorities did not give him the sufficient treatment. Then he wrote so many letters. His wife, she is also professor, I believe. She also has written so many letters. So, the writing, please remember, he wrote letters. My head is burning. Extreme pain is in the abdomen. So, there are no minimum facilities in the jail. And at the time of police escort, they are manhandling me. And actually, on one occasion, he narrowly escaped fall from the chair. It is a relation. So, but therefore, such criminals do have the special, you must have the special provision. This is a classic case. So therefore, to conclude, you can write that basing on the case of G.N. Sai Baba versus State of Maharashtra, definitely the jail authorities should provide minimum facilities to disabled criminals. If not, they should be given bail. So he has got every right to approach the governor for the tender of pardon. This will be sufficient. Question number 17. Remember, the protection of minors and children, it is an important obligation of the state. Definitely. For this, state passed certain enactments. Some of the people say that some of the provisions, they infringe fundamental rights of the people, justify the validity of their enactments. Already yesterday, we have discussed at length about the Child Labor Prohibition Act 1986, Juvenile Justice Act, Domestic Violence Act. So many acts we have done. So here, the protection of minors. So my Guardians and Wards Act is that for the protection of minors and children. So for this, definitely the state has, there were so many acts are there. I will discuss those cases. But some of the provisions, they infringe the fundamental rights of the people. Their allegation is that, but normally when an act is made, they don't actually come across or they don't infringe upon the fundamental rights of the people. Anyway, let us discuss the case. Please remember, child is considered as a national asset and child is the future of the nation. But child is being exploited. How? The exploitations are, number one, sexual molestation. Very recently I have seen the case. 9 years girl sexually molested by 70 years aged person. Second, child marriage. This is rampant in particularly rural areas. There is an act called as Child Marriage Prohibition Act. Sexual molestation. There is an act called as Protection of Children from Sexual Offences Act. Then child prostitution. So this is what is called Prevention of or Suppression of Immoral Traffic Act or Human Trafficking. Child labor. For this, Prevention of Child Labor Act. So many acts are there. Please remember, there is a convention that, as I told you in the human rights case class, United Nations Convention on the Rights of the Child, 1989. So, you know, a child is a person, maybe a girl or a male, who is below 18 years of age. So, the provisions, constitutional provisions which help the children are, number one, Article 21A, you all know, free and compulsory education for the children from 6 to 14 years. Article 24, no child below 14 years, this adolescent, shall be employed to work in any factory, particularly hazardous process. Article 39E, children should not be forced by economic necessity to avocations unsuited for their age or strength. So, ఏ బాయ్ యూ షుడ్ బి ఏబుల్ టు గివెన్ పర్టికులర్ జాబ్, నాట్ అదర్ జాబ్స్. అందుకనే మీకు బాండెడ్ లేబర్ ప్రొహిబిషన్ యాక్ట్ అప్పుడు ఇదే చెప్తాను. వాట్ ఈస్ బాండెడ్ లేబర్? మీరు సూటబుల్, వాడు చదువుకున్న పిల్లలు టీ తెచ్చేవాడు కూడా టీ తెప్పించప్పుడు నేను వాడిని పోయి బస్సులో పార్ట్ రిపేర్ చేయమంటే ఏం చేయగలడు? దట్ ఈస్ వాట్ ఈస్ కాల్డ్ ఆర్టికల్ 45. సో డిపిఎస్పిలో వస్తుంది కదా, ఎర్లీ చైల్డ్హుడ్ కేర్ అండ్ ఎడ్యుకేషన్ ఆఫ్ ద చిల్డ్రన్. So many acts are there for the protection of the minors and the children. The Employment of Children Act 1938, Factories Act 1948, the Child Labor Prohibition and Regulation Act 1986, already we discussed. Juvenile Justice Care and Protection Act 2000, then Right to Education Act 2009. So Guardian and Wards Act, just I told you, 1890. So who is the natural guardian? Father is the natural guardian. But at times court may think that the mother is also the natural guardian. Hindu Minority and Guardianship Act 1956, Hindu Succession Act 1925, and Section 379 IPC. Please remember, selling a minor for a minor girl for prostitution, it is also offense under Indian Penal Code. So many provisions are there, but how they violate the fundamental rights? So normally as a student you negate that point. Normally, Constitution is the mother of all laws. Any law is made, it is in consonance with the Constitution. Your fundamental rights are not definitely. Why? Because what rights? Normally, some people may say the children should work in this. If the only children, not the elders, cannot work, then if you are not allowing the children work, is it not against to right a fundamental right of Article 14, equality? So that is not correct, because children, they should grow up, they should become good citizens, they should not be harassed in the early stage itself. Likewise, property. Yes, definitely, Succession Act is there to protect their property. Like that, so many children, even that mother, when the mother raised objection that my child has to go to the tea stall which is run by us. Yes, there is a leverage in the Protection of Children Act. What it says, the children during their leisure time, they can go and attend their household work. Children can act in TV serials and films also. Now we'll go to the case laws. Number 1, J.P. Unnikrishnan and others versus State of AP 1993. J.P. Unnikrishnan and others versus State of AP. This is regarding right to education of children. Supreme Court held that citizens have got fundamental rights and every child has the right to free education up to 14 years. It is not against to the fundamental, because right to practice any trade or profession, but the basic right is you have to get education. This overriding is the called fundamental right also. Then very important case, whenever this children or it comes Bandhuva Mukti Morcha versus Union of India 1984. Please remember, this is otherwise called as a child labor case. In this case, the Supreme Court held that the court must proceed that or presume that the child labor is nothing but a bonded labor. The state should owe its obligation to identity, release and rehabilitate the labor. ఏషియాడ్ అని మనకు జరిగింది. ఏషియా టైంలో పిల్లలందరినీ పెట్టి ఏషియాడ్ విలేజ్ కన్స్ట్రక్ట్ చేయడానికి గందరగోళం చేసి పరిస్థితి. కాంట్రాక్టర్ సిస్టమ్ వచ్చినట్టు చెప్పిన లేబర్ని వాడారు. ఇట్ ఈస్ అగెన్స్ట్ టు ద ప్రిన్సిపల్ అని చెప్పి ఆ కేసులో కూడా చెప్పడం జరిగింది. యాజ్ రిగార్డ్స్ మైనర్స్, ఉత్తమ్ చంద్ వర్సెస్ మోహన్ దాస్ 1964. So here the minor filed a suit for vacation. His guardian signed on behalf of the minor. Whether this is valid or not, 100% valid. Please remember, minor can file a suit only with the help of his guardian. Right? Another case, Lingo Bhimrao Naik versus Dattatreya Shripada Jamadagni 1937. Please remember, here the accused used undue influence on the minor to sign on certain papers. He said, the minor said, I will sign only after I attain majority. And this man filed a case of tort. He has accepted. So you should not force any minor to act against his conscience. Right? So to conclude, the Child Labor Act 1986 should be amended so that more focus should be given to rehabilitation than regulation. This is my comment. So the judiciary should be more sensitive in dealing with the child labor cases. Benefit of doubt cannot be given to the other persons because children, they are in a volatile position. They may not be able to prove the case beyond all reasonable doubt. So therefore, some laxity should be given. Anyway, to conclude, I want to tell you that protection of the minors and child, definitely it is an integral part, obligation of the state, and state has enacted so many acts, but the only thing is implementation. That is what is necessary. Question number 18. Some women employees work in industry, some are breastfeeding mothers. The employer did not provide proper restrooms, also did not provide substitute relief. Okay. Then they were ordered to work at odd hours also and to work at hazardous premises. Oh, Bhankara case. This case relates to factories. 1948. Factories Act, Labor Code which is 2020 law. So Labor Code will solve all these problems. So please remember, according to Section 47 of the 47 Act, the Factories Act. So please remember, it says there should be provision for shelter, rest and lunch room when more than 150 women workers are there in an industry. Industrial Dispute Act, Factories Act means what? Here the allegations, what are the subjects for discussion? The women employees, they are not, some of them are breastfeeding mothers, of course. To make both ends meet, తింటానికి బతకడానికి పాప వాళ్ళు వర్క్ చేయాల్సిందే, బట్ ఇంటర్మిటెంట్గా పిల్లలకు పాలు ఇవ్వాలి కాబట్టి there should be some rooms. So they did not provide proper restrooms. Number 2, did not provide substitute relief. అంటే ఏంటంటే ఈవిడ వచ్చి పిల్లకి పాలిచ్చి మన తిరిగి వచ్చేంత వరకు ఫ్యాక్టరీ జరగాలి కదా, వేరే వాళ్ళకన్నా పెట్టాలి. Then they are ordered to work at odd hours. Please remember, the woman should not be allowed to work from 6 p.m. to 6 a.m. As per Partc Factories Act 1948, a person cannot work for more than 9 hours. This is section 51. Please remember. Section 61 says, woman should work between 6 a.m. and 7 p.m. నేను వైసీ వెర్సాలో చెప్పాను. So definitely not between 10 p.m. and 5 a.m. Even though that bit మేము చేస్తామన్నా సరే చేయించకూడదు. So please remember. అలాగే 47 provides provision for shelter, rest and lunch room. Already మీకు చెప్పడం జరిగింది. కాబట్టి బ్రెస్ట్ ఫీడింగ్ మదర్స్కి there should be some rest room. అలాగే after days they want to take lunch. So for that common dinner room. జనరల్గా ఏంటంటే ఓ పెద్ద బెల్ వేసి ఒక వాష్ బేసిన్ పెడతారు, అదే లంచ్ రూము, డైనింగ్ రూమ్ అంటారు. ఏదైనా దాని కింద వాటి షేర్స్ ప్రొవైడెడ్. నంబర్ ఎంత 150 ఉమెన్ కన్నా ఎక్కువ ఉంటే సెక్షన్ 47లో. సో దెర్ ఇస్ ఎ కేస్ లా ఆల్సో. తర్వాత మెయిన్ పాయింట్ ఇక్కడ బ్రెస్ట్ ఫీడింగ్ మదర్స్ అన్నారు కాబట్టి దే హ్యావ్ టు ప్రొవైడ్ క్రష్, CRESH. క్రష్ అంటే ఉయ్యాల లాంటి. దట్ ఈస్ ఆల్సో ఐ థింక్ సెక్షన్ 48. Section 48 of Factories Act says regarding the crash. So if more than 30 workers are there, definitely they have to provide a crash. So in this connection you have to remember a case law. State of Gujarat versus Sudhi Mehta, Sudhi Mehta, 1998. So he did not provide crashes. Definitely it is taken as a failure and he was punished. అలాగే 47లో షెల్టర్ రెస్ట్ రూమ్ కోసం కేసులో CK Chokri and CK Chokri and Co. versus Commissioner of Income Tax 2001. So not providing shelter or not providing restrooms is an offense. So please remember. అలాగే Section 52 says the woman should not be allowed to work on holiday. If at all there is a necessity from the workers, for the women workers, ఆడవాళ్ళే పనిచేయాలంటే they should get compensatory leave. This was decided in KVV Sharma, manager versus unknown, 1952. So this is a genuine problem. Court held that this is a genuine problem. No doubt the woman could not disclose her name. Unknown annaru. Genuine problem. So woman should not be given to work, should not allowed to work on holiday. If at all she works on holiday, definitely she should be compensated. ఇంకో రోజు ఎక్స్ట్రా లీవ్ ఇవ్వాలి. And also please remember, hazardous process, you know, which is a dangerous process. So, kabatti, the health and medical condition of the records of the workers should be maintained. So, section 22 ఏం చెప్పుదంటే, no woman shall be allowed to clean any part which would expose a woman to risk of injury. హెజార్డస్ ప్రాసెస్లో వర్క్ చేయటమే కాదు, అక్కడ తోడవటానికి కూడా ఆడవాళ్ళని పెట్టకూడదు. ఎందుకంటే ఈ కాటన్తో ప్రెస్ చేయి ఊడమంటారు, ఈ కాటన్ తగులుకుని ఒకసారి హెజార్డ్ ప్రాసెస్లో ఫైర్ అయింది. అందుకని చెప్పి హెజార్డస్ ప్రాసెస్లో ది ఉమెన్ షుడ్ నాట్ బి అలౌడ్ టు వర్క్. సో దీస్ ఆర్ ఆల్ ది కేస్ లాస్. ఇంటర్మీడియట్గా మళ్ళీ కేస్ లాస్ చెప్పాను. టు కంక్లూడ్, సో ప్లీజ్ రిమెంబర్, ఇట్ ఈస్ ది డ్యూటీ ఆఫ్ ది స్టేట్, ఇట్ ఈస్ ది డ్యూటీ ఆఫ్ ది ఇండస్ట్రీ, ఇట్ ఈస్ ద డ్యూటీ ఆఫ్ ది ఫ్యాక్టరీ టు ప్రొవైడ్ crashes for the breastfeeding mothers, to provide restrooms for the working women if they are more than 150 in number, to provide dining rooms for the workers. This is all for the women workers. Definitely they have to follow. If they do not follow, definitely action can be taken under Factories Act or whatever act is available to the concerned parties. So with this I am stopping. I think we have discussed the question papers of 2017. If there is any time, tomorrow or after tomorrow, I will give a message and discuss 2016 question papers. With this I am closing. So please inform all your friends, get ready within 5 minutes. Suppose if I give a call, within 5 minutes you must be ready to just activate your mobile phones so that it will be helpful for you. Right? Thank you very much.